You're welcome to my channel. In this video, we are going to be continuing with the cases in business law. Shall start with Haley Hutchison's case. It was stated that where a director has not disclosed his interest in the contract, this does not make the contract void but voidable. Then in the case of Passiver versus Wright, it talks about the duty of good faith. It says that the duty of good faith is owed to the company and not to the individual shareholders. Yeah, and this is under the part of prohibition of insider trading. Yeah. Then in the case of Real London and General Bank, it talks about the standard duty of the auditor. It was stated that an auditor is not bound to do more than exercise reasonable care and skill in making inquiries and investigation, even in the case of suspicion. Then the case of Fermento into bracket stealing area versus Seldon Fountain Pen Company Limited. Yeah. While Lord Benning stated that an auditor is not to be confined to checking vouchers and adding or subtracting figures, but he must take care that errors are not made and should approach his duty suspecting that someone may have made a mistake and have a check done to ensure that none has been made. Yeah, so this case says that it's not the auditor's duty to check, subtract, or add vouchers, but his duty is to make sure that there are no errors in the book of account for the company. Yeah. Then there is a case of Panorama Development, Guildford Limited versus Fidelis Furnishing Fabrics Limited. Yeah. In this case, court pointed out that the secretary is an important officer of the company with exhaustive powers, duties, and responsibility, who can make representations on behalf of the company and enter into contracts in the day-to-day running of the company's business. Yeah. So this one talks about the secretary, the company secretary, and the powers that a secretary has. Then there is a case of Smithfield Butchery Company. Yeah, it was stated that the wrongful acts committed by the subordinate staff of the company will not attach liability to a company. Yeah, it talks about the liability of the officers of the company. If the officers commit the wrongs on their own, the company will not be liable. Yeah, it was stated that the wrongful act committed by the subordinate staff of the company will not attach liability to a company. Then there is a case of Force versus Haboto. Yeah, this case talks about personal actions under enforcement of members' rights under case law. Yeah. In this case, it was stated that when the wrong has been committed to the company, the proper plaintiff to sue for the wrong is the company and not the shareholders or the members of the company. Yeah, it talks about personal action, acting on your own. Yeah. When the wrong has been committed to the company, the proper plaintiff is the company and not the shareholders. That is the case of Force versus Haboto. Then we have another case of Misango versus Musijiri. It talks about the exceptions. It talks about the exception to Force versus Haboto, and this is infringement of personal rights of members. Then we have the Daniels case. It talks about the interest of justice, which is also an exception to Force versus Haboto. Yeah, then we have another case of Reindigent Tobacco Company Limited. Yeah. Here the directors hated each other so much that the company had to be wound up. So this one talks about the kinds of wrongs that can be entertained under just and equitable clause, whereby there is a deadlock between directors who are the only shareholders. So in this case, the directors hated each other and they had to wind up the company. Yeah. Then in the case of Elder versus Elder and Watford, this case is under the operations section. Court defined operation as a visible departure from the standards of fair dealings and violation of the conditions of fair play on which every shareholder is entitled to rely. Then we have the case of Re H.R. Hammer Limited. In this case, this case is also under the operation section. It was held that operation amounts to conduct by the majority which is harsh, burdensome, and wrongful. Then there is a case of Eliezer Wambale Company Limited. Application by members to the registrar to carry out investigation. Talks about application by members to carry out investigation, and application will not be entertained if the other remedies available. Then there is a case of Oreo Gold Mining Company of India Y. Roper. It was held that shares are not to be issued at a discount, and whoever takes shares in return for cash must pay the full nominal value of the shares. We have another case of Trevor versus Waitworth. It was held that it is illegal for a company to purchase its own shares, even if the memorandum gives express authority to do so. Then we have a case of Lee versus Neuchatel Asphalt Company. Court held that there is nothing at all in the Act about how dividends are to be paid, nor how profits are to be recommended. Losses of capital need to be made good before the company declares dividends. Then in the case of Makidayo Oneka versus Wines and Spirits, in this case the principle was laid that unless the articles and terms of the issue of shares confer a right upon a shareholder to compel a company to pay dividends, it's the discretion of the directors to recommend a general meeting that a dividend is declared. So this is the main issue, is the discretion of the directors to recommend a general meeting that a dividend has been declared. Then in the case of Nash versus Lind, it says for a document to amount to a prospectus, not only must it be delivered, but also must have some form of publicity with the aim of inducing subscription. Then in the case of Brown versus British Apprehensive Will Company, in this case, court declared the resolution for the new article invalid as it amounted to exploitation of the plaintiff's share. It talks about fraud on the minority. Then in the case of Edwards versus Hadrell, Jenkins LJ laid down the tests where the rule in force versus Haboto may be departed from, where a company shareholders are acting or about to act ultra vires is beyond power. The rule in force versus Haboto may be departed from. We say the rule in force versus Haboto, a company is supposed to sue on its own and not the shareholder. It talks about personal action. But where the company's shareholders are acting or about to act ultra vires, a member can sue on behalf of the company. Ultra vires is acting beyond power. Then where the act being complained of, though not ultra vires, is illegal but could be effectively resolved by a mere simple majority vote. Where the act is illegal, then where it's alleged that the personal rights of the plaintiff are infringed or about to be infringed. Infringed is like violated. Where the personal rights of the plaintiff are being violated or about to be violated. Then where those who control the company are the same people that are carrying out fraud on a minority shareholder. A shareholder can go to court instead of the company itself. Then we have the case of Daniel versus Daniels. Yeah, in this case, court held that fraud on the minority covers more than fraud, and in the strict sense, and an action would be allowed in respect of any fault without fraud. Then there is also a case of Hailiting versus DuPont, where a court held that the categories of exceptions in the rule of force versus aborto could not be closed, since under certain instances the interest of justice may demand that the rule be bypassed by a minority shareholder. We have a case of Mcduck versus Gadina. In this case, the court pointed out that if every dispute about the internal management of companies had to be brought to court, the court would be overwhelmed with cases. Yeah, so it's the reason why they came up with the rule in force versus aborto of personal action. Yeah, if every dispute about internal management of companies had to be brought to court, the court would be overwhelmed with cases. That's the case of Mcduck versus Gadina. Then in the case of Merrill versus Whiteley, court said that the rule in force versus aborto serves the purpose of preventing the company from being torn to pieces by litigation. Litigation is about court issues. Yeah. So in this case, court said that the rule in force versus aborto serves the purpose of preventing the company from being torn to pieces. Yeah. A member is not allowed to sue on behalf of the company unless otherwise, because there are some exceptions. Yeah, so this rule in force versus aborto serves the purpose of preventing the company from being torn to pieces by litigation. Yeah, thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video, which I'll be talking about more cases in business law too.